So here we are at the 918 form, Part 1, Information About You. The family name is, just as we've entered into Abacus, both last names, and then the given and middle names. Other names is not just the first name and the first of the last names. It's really seriously other names you've used, including maiden name, nickname, and false names that somebody may have used. Sometimes you'll find that on the police report that it's under a different name because your applicant didn't want to give their actual name to the Immigration Service. Sometimes they work under false names. We want to be sure to have those names here in case they, mostly we just want to be as candid as possible with immigration. And our experience with the crime victim unit at the Vermont Service Center is that they have not used the information in the I-918 form for any kind of enforcement activity. So the same is true here of the home address. I have always used the actual home address, but there are some practitioners who prefer to use only the attorney's address, or say confidential address can't use in this place. I think the only reason not to use the home address, based on my experience of immigration not using it for enforcement, is if the home address is the address with the abuser and you want to be sure that nothing comes from the Immigration Service to that address, then I would say confidential address here. Other than that, our practice is to put the applicant's actual home address. The safe mailing address, however, is our address. It's 3543 18th Street, Mailbox 32. Care of Immigration Center for Women and Children, San Francisco, California, 9410. The home telephone number will be the applicant's phone number. The safe daytime phone is ours, and email address, you don't have to put yours here. You are going to be including yours at the last page of the application. So you can say none, or you can actually put the applicant's email address there. I don't think immigration has ever used those to contact an applicant, however. A number and U.S. Social Security number, go ahead and put none. I used to just leave them blank because it specifically seems to say they don't want it. But I have learned that just leaving them blank may leave the implication that you forgot to fill it out. The yes, no, or any of the boxes, if you are using this in Abacus, I'm actually using this at the USCIS website's PDF. In Abacus, you have to double-click to get the X in place, but here I have only single-clicked. Marital status, that's essential. The date of birth, the country of birth, the country of citizenship, those are all pretty easy. The passport, our applicants should have passports. They may not have it when you first fill out the I-918, and so you'll need to go back and fill that out before you send in the application. It is okay to have some handwritten information in the application. When we originally did I-918 applications, they were all by hand because the form hadn't actually even come out yet. And then even when it did come out, it didn't come out in a form that was in a form software. So we did all of ours by hand. But we do encourage applicants to get their passports. It's actually one of our required documents. About 2% of our applicants can't afford a passport, or there's some other hitch. And so you'll just talk to whoever your supervising attorney is about whether they don't have to have it. Now, some minor applicants won't be able to get their passport number because they have an abusive parent or a non-present parent who can't sign for or won't sign for them to get their passport, because the passport is actually a travel document, and the consulate of that person's home country won't issue a passport if it thinks that the child might get transported without the other parent's permission out of the country. So that's why it's hard to get a passport, and in those cases we can waive it with the I-192 if the child is in the United States, or with the I-193 if they are outside of the United States. But generally we are going to have a passport, certainly for the principal applicant who's an adult. Okay, the place of last entry and the date of last entry. The date, you can say, you can say 1996 if you absolutely have to, but the closer we can get to the actual date, the better. So March of 1996, and the person may be able to remember because of what time of year it was when they came in, or whose birthday it was, what occasion they were coming from for, whether it was summer or winter. But it's not critical. You're not going to get an application denied because you can't get it exactly. The place of last entry is in the United States. So some people actually enter on visas and they come to an airport like SFO or LAX, New York City, Boston. However, most of our clients come without documents, or they come with some are what's called waived, which just means that they're riding in a car and the border agent just says go on ahead through it to the driver of the car. And the driver will show documents or not, and some people actually are able to enter the country in that way. Those few people who do come in that way can consider themselves to have passed through an actual point of entry like San Isidro, so they may even know what that is. Other than that, what we use is the city closest to where they came into the United States, and we have a map of the border between Mexico and the United States that we often have to consult. Most of our clients come through what they'll say is Tijuana. We write San Diego because we put the U.S. side, and we then say California. So San Diego, California. Other common places to enter are Calexico, California, Douglas, Arizona, which is on the other side of the border from Agua Prieta. El Paso, Texas is a very common crossing place. Brownsville, Texas. So we'll just take a look at the map if we need to, but frequently somebody knows. Now, often somebody will tell you, I came to Oakland or I came to Los Angeles. We need to press them a little more and find out where they actually crossed the border. Now, none of this is essential. None of it's going to make somebody's application get denied. I don't even know why it's that essential to immigration. I think it's because they've based the I-918 on all of their applications for status, and so they will... and so they want to know, they're assuming that the person entered legally, and that's why they even have the place of last entry. But that's obviously not going to be a concern, so much of an issue with people who didn't cross lawfully, but we want to at least give the old college try to say what it is. The I-94 is a little white piece of paper that is actually now being transformed into an electronic document. But the I-94 will have a number on it, and it will only be for people who entered with inspection with a passport that this will accompany. A lot of people don't keep the I-94 form, so you can say unknown if they did enter with an I-94 and they can't find it, or none. Current immigration status, I like none, which is usually what people have. In Abacus, where I am here is now on the far right at the bottom. You need to give either Jess or my an attorney number, unless you are also a sworn attorney. Mine is 169469, but you'll have to write that in by hand on the Abacus form because it won't let us fill it out there. Okay, part 2, are questions about whether somebody qualifies for U non-immigrant status. Therefore, they are all yes, so except for 16. So these are all, I am a victim of crime, I suffered substantial abuse, I was helpful. Then I'm under 16. Most of our clients will say no, but you'll obviously know. Every single one wants employment authorization. Okay, here comes our big first meaty one. Have you ever been in immigration proceedings? Before 1996, what is now called removal was called exclusion, which meant you were not admitted, or deportation, which meant you were already in the United States and you were deported from the United States. That doesn't exist anymore. It hasn't existed since 1996. So now if somebody has been officially removed from some kind of official proceeding, they will be removed. So if they've already been ordered removed or they have already been removed, you'll put that date here. If they're still in removal proceedings, you'll mark judicial date and put the date that they are next supposed to go to court. So what is removal? I have made for you a list of all, I've annotated with footnotes an I-918 form, and you should have it with your materials, and I describe in detail which each of these items is. But removal is either accomplished by an immigration judge making an individual determination on whether somebody can remain in the United States or not. And the person will have appeared in immigration court and they should know whether they've been removed or not. If the person has any kind of documentation that has an A at the beginning of an 8 or 9 letter series, you can call an 800 number that will tell you what the outcome was of that person's removal proceedings, when they were removed, where they were removed, and then you'll be able to put that date here. Sometimes people won't know exactly, and you'll try to approximate. Hopefully they have something that you can look it up and give some accurate information here. So that's one kind of removal, where they appeared at immigration court and were ordered deported by a judge. There are 2 other ways in which someone might have been removed. One, and we are going over this with our whole how you even analyze a case, is called expedited removal, which is a procedure that was not created until 1996 and didn't start to be implemented in 2001, and even then only in limited areas in Texas and Arizona. And it involves, and we have a lot of sheets about how do you analyze whether it was an expedited removal or a voluntary return or voluntary departure. Expedited removal is a formal removal process that is able to be carried out by an administrative agency, either ICE or Customs and Border Protection, within 100 miles of the border or within 1 year of the person entering the United States. It doesn't always happen. Frequently there are other forms of making someone leave the country, but this is this very formal process, and it involves getting all 10 fingerprints taken. You see 2 different officers. You answer questions about whether you have a well-founded fear of persecution in your home country. You sign forms, you initial things. We've got a very detailed analysis about whether that would be an expedited removal or not. And so I would say probably 5% of the clients that we have that were caught at the border have expedited removals. You'll also sometimes find it when you get the FBI results. It will say expedited removal or false documents or false claim of U.S. citizenship. When we are sure that it happens when somebody is using false documents and they get caught. Those are almost all expedited removals. The other kind of removal is where a child or maybe a pregnant mom is taken into custody at the border, and then they are given something called parole. They are allowed to leave the custody and go into the United States. But they are not actually admitted. They are told that they are going to get a notice to appear in court. I don't know anybody who's ever actually appeared in court at that. Okay, there is one person who appeared in court. They asked for asylum, they were denied. But generally somebody says, wow, I'm free to go. They never gave a real address because they were afraid. So their notice to appear in court is sent to this fake address. They never get it. They don't show up for court. They are ordered deported in absentia, or removed in absentia. Sorry to use the old word. So those people also have a removal date. They may not know what it is. So the answer on all of these things is you might try to figure that out with the person. Sometimes they might have also an A number, so you'll try to find out whether the person had that kind of interaction, or whether they might have any possible piece of paper left over from that. It's okay to say yes or no, as long as you give an accurate account in your explanation of this answer. You'll see here that it says, if you answer yes to any questions, you should attach an explanation. We ignore that for these first questions about eligibility because we think it's just sort of given. But with these, you can say yes if you think that you were removed and put the date you think you were removed. But then when you attach an explanation, you will say, I think this is what happened. I'm not totally sure. So I'm going to show you where in our server we have, come on. I'm not actually in the server, so I'm just showing you a screenshot of it. But if you go to Shared Documents, and then you go to, I've got all my favorites here, but within Shared, you'll go to exclamation mark U visas, exclamation mark U practice materials, forms, and then attachments to 918s, and then stock attachments to the 918. There are little things that just at the top, they just say attachment to the I-918 and show you a place where you'll put the person's name. And it'll say explanation for a yes answer to part 2, question 8. And there you'll just say in narrative form what happened. I crossed the border near Douglas, Arizona. I was apprehended. I was told that I had to leave right away, but I wasn't able to leave. Instead, they held us for another 8 hours until there were enough people there to take a bus, and they took us back about 25 miles into the interior of Mexico and let us go. Or, I said I didn't want to see a judge, or just write the person's story of whatever happened. As long as the person is candid, it's not essential that you're completely correct on the yes or no. Of course, if you do know, you've got to answer the right thing. Some practitioners, and I've done this too, when it really is a toss-up and I really can't tell, sometimes I'll put a little asterisk in there. But really, there is no harm in saying yes if you adequately explain it. Number 9 is list each date, place of entry, and status in which you entered the United States during the 5 years before the application. So don't put it if it was more than 5 years ago. And if it may be the same as what you wrote up here, place of last entry, date of last entry. Or if the person had one before that, that was also within the last 5 years, you'll include both of those there. So you only put it here if it's in the last 5 years. Status of entry, again, is none. Place of entry is in the United States. Okay, part 2, additional information, question 10, you don't need. Okay, now we're getting into the criminal questions. And some complex things come up here. And also, this is going to be a place where we are going to use the concept of RRR. RRR stands for... take responsibility, express remorse, and demonstrate rehabilitation. So say someone has committed petty theft, and she may not necessarily, or he may not want to admit it to you because it's embarrassing and it's not the kind of person they want to be, and it's not the kind of person they want you to think that they are. So often you will have somebody who say, my friend put something in my purse and then I got caught, or my friend put something in my baby's stroller or my child took something. It's very difficult to tell with a client, but you can make them know that it is okay that it happened, because this is their opportunity to get it off their chest and to get it waived for immigration purposes, because everything except being a persecutor of others is waivable with the U visa if you just can give enough positive equities. So this is the time to really be forthcoming and admit any mistakes that somebody has made. Not only to admit it, but to say, yes, I did it. So that's the accepting responsibility. Then the expressing remorse. And it was stupid, and I felt terrible. And I didn't realize before I did this and before I was arrested how serious it is to take from a store. I always thought a store was a big impersonal place. I now realize that the only way we can have, a system like the stores that we have is if people are honest. I feel terrible about it. So that's the expressing remorse. And then there is demonstrating rehabilitation. You should definitely say, I will never do it again. You definitely want to express rehabilitation, but also find some way to say the way in which you are different. We had a client who had, she had a petty offense at one point, and learned from it, and was humiliated and shamed and vowed to change her life. And then the way she could demonstrate that she changed her life is that she was in a grocery store, and there was a $20 bill on the floor in front of her when she was in the checkout line, and she put her foot over the bill because she thought, oh my gosh, I'm so broke. I want to be able to buy a special treat for my kids, and I know this probably belongs to somebody else, but they obviously don't need it, they don't care about it, or they wouldn't have been so sloppy. So she put her foot over it so that she could wait until whoever could have dropped it would be out of the store before surreptitiously picking it up. And then she thought about the shame she had felt when she had been dishonest before, And she thought about what she would tell her little girls when she told them, oh, I found this $20 and I bought this for you. And how she would say, she would normally want to teach them, if you find money on the ground, you would always ask who it belongs to. So she thought of how she would explain that to her daughters. And she decided to pick up the money and ask whose it was. I mean, the person in front of her, it was that person's $20 bill. And they were so grateful. And she felt so much more than $20 worth of pride and happiness and joy in making this connection with this woman. And so she was able to write that in her explanation to demonstrate that she really had learned her lesson about honesty. Anyway, so I'm leading quite a bit. Given all that about how important it is to be totally honest, the first question, 1A, have you ever committed a crime for which you have not been arrested? We tend to say no unless somebody really wants to get something off their chest. And in fact, I was at a training once with immigration officials, and they said the purpose of that question, immigration doesn't want to have to get into hearing every detail of somebody's life. What I often say is, I kicked my sister once, and that's assault and battery, but I would not admit to having committed that, and I didn't when I filled out my bar application. I'm pretty sure the bar official doesn't want to know every time that I had a fight with my sister. So it can be if somebody really wants to get something off their chest, but that is just a stock question that's on every immigration application. It's not really taken very seriously unless there is a serious crime. Now, the problem with a serious crime is in order to know that you committed a crime or offense, you kind of have to know the elements of the crime or offense, and most of our clients are not lawyers. Most of them don't know that driving without a license is a crime, and we are absolutely certain that immigration does not want to hear, yes, I committed a crime, I entered the United States unlawfully, because this whole application is for people who entered unlawfully. So most people will say no. In fact, if you ask them, they will say no. So generally that's going to be no. The only time we ever say yes is sometimes we realize that somebody has gotten an overpayment in welfare. And we actually make them, instead of saying yes, we make them go get that taken care of before they even apply. But if somebody has been threatened with arrest because they've shoplifted, is the place where I've seen people want to say yes here, because they feel so ashamed about it and so much want the opportunity to say they now know that was wrong. Okay, B, have you ever been arrested, cited, or detained by any law enforcement, including the Department of Homeland Security, which is immigration? And a lot of our clients will say yes to this for a number of reasons that aren't crimes. Being pulled over is a detention by law enforcement. So getting just being pulled over for a fix-it ticket or for speeding or an unsafe lane change is going to be a yes answer here, as is being detained at the border and turned back. Even if it was not an expedited removal, it was still a detention by a law enforcement officer, so you'll say yes. As soon as you say yes, you come down to this little chart down here, and you type in here, attempted entry to U.S. And the date was whenever you can remember that was, 3/2006. Where was it? It was in San Diego. And the outcome was you returned to Mexico. You don't have to also tell the whole story that right after that you came right back to the United States. So this person may also have a ticket. So they got a ticket for speeding in 4/2008, and that happened in Oakland, Parkland, and they paid their ticket. Okay, so all of their tickets. Now, the reason I said 4 up here, it says it wants the actual day. That would be ideal. Some people do keep their tickets. We actually spend a lot of time trying to figure out what the dates of all the tickets were. If somebody absolutely cannot figure it out, I will say traffic tickets between 4/2008 to 9/2012, and Oakland and San Francisco. and then paid tickets. So for these little things, this is all you need. If, however, it was an arrest for something substantial, like a driving under the influence, or a domestic violence, or theft, in addition to filling out this little box, they also have to write an explanation. So you need to tell the client's story here and of what happened, and that is their RRR statement. This is what happened. I accept responsibility. It was a bad thing to do, and here's how I can assure you that it won't happen again. So here in this same U Practice Materials Forms U Visa folder in the attachments to the I-918, we have some model explanations for arrests that include those RRR statements, and you can see that it's for petty theft and for domestic violence and for somebody got arrested a lot of times for a lot of petty things, and so he ended up just saying it was all because of drinking, and now I don't drink anymore, and here's evidence of that. We have one for interfering with an arrest. So we get a number of receiving stolen property, because we have clients who sell things at the flea market and they can get arrested for that. So there are a bunch of things that you might want to look through when you have a chance in here. And so that explanation is essential, and it goes after the signature page of the I-918. I also include it. We're in the process of reviewing this policy. We have traditionally included evidence. In fact, you have to include copies of arrest reports, court dockets that say what the outcome was. If it was a DUI, some evidence that the person completed their courses, and the most final documentation that you can get that showed the last thing that happened in that case that the client is able to get. And you'll see when you do your first appointment, on the documentation list, it says if the person has an arrest, they have to get it is their job to go to the court where they were charged to get the outcome, the docket sheet, or the disposition of that crime. So that and this RRR statement get attached to the I-918. Okay, so that was just 1B. So B has law enforcement, has a police officer or a CBP agent detained or arrested you. The next is the next level up, which is that the district attorney or some prosecuting official charged you. That's a higher burden that the government has to make, and so it's a little more serious. You'll add that in that same RRR statement, because you aren't going to get charged without having. You're already going to be in the process of explaining it just because of the arrest. Obviously, being convicted is one step more serious, and they want to know even if it was expunged or pardoned. What they want to know is what happened, not what the final outcome was. So this is invasive. It's more. The Immigration Service has the right to ask all of these things because you are asking for a benefit. And so there are personal questions, and people will feel a little defensive. And once again, you just have to assure them that you want to spill everything at this point. For one, because immigration is going to have a copy of their FBI. They're going to have a copy of their alien file, every contact they've ever had with immigration. And so immigration will know it, so now is their time to explain it. And also that this is their chance to have it waived. Okay. So alternative sentencing, we now have this with drug offenses in California. We used to have it with drugs and other offenses. It's where instead of having to plead guilty to an offense or go all the way through trial, there is some kind of diversion or rehabilitation that you can instead choose, and you don't have to have that guilty plea on your record or that guilty finding on your record. Most people, people ought to know, and they can contact their criminal defense attorney if they aren't sure. Again, if you can't find it because the criminal defense attorney isn't around, you can put yes question mark or no question mark, as long as in the explanation you say exactly what did happen. Suspended sentence or probation are similar. It's the same as, and there's also conditional sentence. What it essentially means is that you have a maximum sentence of, say, 3 years. And if you comply with all the terms of the probation, you don't get in trouble again. You don't have to serve that 3 years. But during that 3 years, if you do something that that triggers any of the criteria in your conviction report, then the 3 years will be imposed. So so that's kind of serious. A lot of times people will say, I only spent a week in jail, but they did have a conditional sentence for 3 years. So so it is somewhat serious. Been in jail or prison, so a lot of times with somebody with a DUI, they have been in jail or in prison. Have they ever gotten a pardon or amnesty? People often wonder about amnesty of immigration applications. Most of the people, I don't think I've ever seen anybody who's gotten a pardon or an amnesty or active clemency. Similarly, I've never seen anybody who was able to exercise diplomatic immunity. Okay? So that is crimes. Now we can move along to public assistance. You'll notice that, well, I guess they do, yeah, we do have to, we don't write an explanation on a separate form for public assistance. Immigration has said that they will not consider receipt of public assistance as a negative factor in a U visa determination. So I usually just kind of write in here what they got. So it even specifies that emergency medical treatment is not going to be included. So what they mean by public assistance is means-tested public benefits. So in California, there's CalWORKS, which is aid to families with needy children. Food stamps would be. Medi-Cal, generally immigration has told us that if you're getting assistance for your children, you don't have to say yes. We generally sort of leave it to the client in that case. Some people really do want to state what they have received, and we are happy to write that down and say yes. Other people, again, this is not an important question. So we can just say, I got Medi-Cal to have my children, or I got Medi-Cal to take care of my injuries from having been a crime victim, or my children receive food stamps. It's not going to affect anything, and so being candid is good. Number 3, prostitution, commercialized vice. We don't get a lot of yeses, but actually prostitution within the 10 years prior to applying for an immigration benefit is a 10-year bar to, unless it's waived, it's a 10-year bar to being admitted to the United States. Fortunately, as I've mentioned before, everything is waivable. And so it's fine to say yes and then just request a waiver of prostitution. Most of ours haven't had any other kinds of commercialized vice. 3C, have you ever knowingly encouraged, induced, assisted, abetted, or aided any alien to enter U.S. illegally? People will always say no to this question. And then you say, I see that your wife and children entered a year after you did. Are you sure you didn't help them with paying the coyote? And they'll say, oh, yes, well, I did that, but I didn't physically try to help them across. Those people should still say yes. And then the explanation is really pretty easy and straightforward. I don't think I have that. These are just the crimes ones. But we have some in the stock short attachments for alien smuggling here. And it basically just says, it was my family member. I'm sorry. I regret it. I now want to obey with all immigration laws. I believe in immigration laws, and I wish that I had obeyed them, is a good way to put that. So this is frequently yes, even if people initially think that that's no. Usually people think of alien smuggling as what the coyote does, not what the person who is just trying to help pay for it or encourage somebody to come. So that's frequently yes, and don't worry about it. It's never been a problem in the U-Visa context. Okay. Illicit trafficking in controlled substances, that's going to be incredibly serious. I think that usually by circumstantial evidence you'll find out this kind of information. I haven't seen any yeses in ages. I think I've only ever seen one. And again, that's waivable, but that's a really serious offense. If immigration has reason to believe that somebody is a drug trafficker, they take that very seriously, and that's going to be that's going to require an enormous waiver. So if somebody does answer that yes, please bring it to our attention. Number 4, all of these, number 4, number 5, we actually have people watch a video where Monica asks people all these questions. And so you can just feel free to have them answer these on their own. What I do is I try to assure people beforehand that, again, nobody thinks that just because you're applying for a U visa, you are particularly likely to have done any of these terrorist kind of activities. These are just on every immigration application, and it's actually a good thing. They're looking to keep the United States safe. They are trying to keep out people who have perpetrated crimes against other people, and so most people don't even have to worry about these questions at all. Zooming on ahead. Biological agents, most people aren't going to do that. Similarly with 6, are you planning to be a spy or overthrow the government of the United States? Have you ever been a member of the Communist Party? I haven't found anybody in the U visa context who has been. Sometimes with old naturalization applications, people from the former Soviet Union had to be members of the Communist Party, but these are very rare among our clients. Number 8 is always a really fun one to even, when you're sending somebody off to see the video, to talk about how absurd the questions are and how they shouldn't worry about the ones about terrorism. It asks all these people who were born in the 70s if before 1945 they'd been a member of the Nazi Party, and that's always a good thing to get people chuckling. Then we go into ones where they're really looking for people who've persecuted other people on the basis of their race, religion, etc. So that's what they're getting at in question 9. Have you ever ordered or committed or helped with or participated in killing or beating any other person? If somebody's been a member of a military in which that occurred, we helped somebody who was a member of the Israeli military. He didn't answer any of these. Yes, he actually did. He had to say, yes, I may have killed somebody. We fired weapons in their direction with the intent of killing them, and so although I was under orders to do it, I never saw anybody that I killed, but there's a good chance that I did kill people. He got his waiver approved. Have you ever advocated that another person do any of those things? That's generally going to be yes. Have you ever been present or nearby when somebody was killed, beaten, displaced? We used to answer this yes for our clients who had themselves been beaten or displaced or assaulted. And now we only do it if it was somebody else. Again, they're getting at people who might have witnessed or been a party to persecution against people for their beliefs in another country. And so it's not critical that you answer all of these. But sometimes you will find those. And in your annotated packet, we have some explanations for someone who had seen somebody beaten in his hometown because of being a member of a political party. So there are some of those examples. So just most people, when they go through through that video, they will mark most of these no, because most of our people are pretty simple and they haven't done any kind of military training or anything like that. But 14 have removal. Remember, that's what the process is now. Exclusion prior to 96. Rescission. I forgot to mention that rescission is if somebody already has their permanent residence and it is taken away in a formal procedure with proper due process, then their status was rescinded. We have never had somebody whose status was rescinded as a U visa applicant. Deportation proceedings. Some people want to say yes with these, even if what they got was voluntary departure at the border. So again, somebody was picked up along with a group of people. They were told, a fingerprint was taken. They maybe gave a false name, maybe they gave their real name, and they were driven back to the interior and let go. that is not a deportation. It's not a deportation, or it's not a removal. Nothing is a deportation since '96, but they may consider it a deportation. And so I've had a lot of volunteers want to mark yes here, even when it's a voluntary departure. Here's another situation in which you'll have a voluntary departure other than at the border. So somebody is picked up for DUI or burglary or something in the United States. They're taken to jail, and once they're in jail, ICE finds them, gets them off of a list and asks that the jail hold them on what's called the detainer until ICE can determine whether the person is going to get seen by an immigration judge or whether they will accept voluntary departure. Voluntary departure is a process where you don't get a deportation on your record, but you are taken out of the United States at government expense. So, and then you're flown out. A lot of people feel as though that was a deportation. It generally is not. Most people, well, you would know if you were being deported or removed if you're in the interior of the United States, because you would have seen an immigration judge. So you would have gone to an immigration judge in shackles or in your in an orange jumpsuit. You would have appeared in front of one of two immigration judges in San Francisco, and you would have, admitted to allegations. You would know. You would have taken a bus from Santa Rita to the immigration court. And so most people will accept at that point voluntary departure. They sign forms to leave the United States. And I have a copy of that in your materials. It's an acknowledgement of voluntary departure that says, I know I have the right to see a judge. I'm not exercising that right. So, and then even if somebody has been removed, there are some funny questions here. So, are they currently pending against you? That's only going to be if you have an open immigration court hearing, so you've got a date in the future. Have they ever been initiated against you? Yes, because you're in them now. But that could also be bigger than that. The Venn diagram is a little bit bigger. This can also include ones where you were already ordered removed. Have you ever been removed from the United States? Some people can be ordered removed from the United States and not leave. Some people can be ordered to voluntarily depart the United States and then not leave, and that turns into a removal order. So that's where we have a little complexity here. But so, have they ever been initiated against you? You would say yes, even if you ended up with voluntary departure. So just the yes here is going to let you explain what exactly happened. The judge said that I had 90 days to leave the United States, but I didn't leave. Just so long as you kind of have a place here to flag for the Immigration Service that you have an explanation where you're going to be candid about what happened. Have you ever been removed? So it was actually enforced, and did you get taken out of the United States in a formal proceeding? So either expedited removal or removal via a judge. Have you ever been ordered to be? So this is if the judge made an order for you to leave, and often again, you're going to have several of these in one. Have you ever been denied a visa? So we say yes. If back in question 1B, you said you had been detained at the border, you were also denied admission to the United States at that point. So you'll say yes. So I would say 50% of our clients will say yes to having been detained by law enforcement and to having been denied admission to the United States. And then you will write an explanation that we have written many, many, many times on, on such and such a date. I was caught trying to enter the United States. They took my fingerprints. I gave them my name, or I gave them a false name. And after a few hours, we were taken back to Mexico. So, and then some people will say, I actually am from El Salvador, but I said that I was from Mexico, so I would be returned to Mexico. That is fine for them to say that and admit that they engaged in fraud there. And then we'll actually answer that below here too. So have you ever been granted voluntary departure by an immigration officer or an immigration judge and failed to depart within the allotted time? That is not an infrequent occurrence where somebody will be in some kind of proceeding, say cancellation of removal, where they've asked the judge to not to remove them based on extreme hardship to their children or something. And the judge won't grant them that, but will permit them sufficient time to leave the United States, usually because they have kids and they want to get their things in order. But instead they disappear and don't depart. When that 90 days or whatever the period the judge gave them passes, that turns into a removal. And so they have an outstanding removal order that can be executed at any time by the Immigration Service. And so that person, it's great for that person to apply for U status anyway, just to try to have an opportunity to get that cleared up. Right now, actually, the Immigration Service is not granting adjustment of status after the 3 years in U status to people who have overstayed a voluntary departure. So we're going to have to ask the Immigration Service to join us in motions to reopen those proceedings in immigration court. It's a little catch-22 right now because the ICE trial attorneys want to wait until after the person is adjusted status before they will join in a motion to reopen in order to terminate those proceedings. But I have never seen anybody get removed as a result of after they've gotten their U status based on this. And instead, what I think immigration is doing right now is it's just pending those U status applications. So the person filed timely. They're still in status. They can renew their work permit, and they're not going to be removed as a result of it, but it's still in a little bit of limbo. So that, again, is this formal thing called voluntary departure that was granted by an immigration judge if it's here in the United States. So it's different than something where at the border you actually did leave after you were granted voluntary departure. And certainly if you're given voluntary departure by ICE while you're in jail, you will have already been taken out of the United States. The advantage of getting a voluntary departure is that you don't have a removal on your record. So if somebody has some way to be able to immigrate, like through an immediate relative petition or something like that, if they have a removal on their order, they're going to have a 5 or a 10-year bar to being able to immigrate legally to the United States. So that's why they would want voluntary departure instead of a removal on their record. It's advantageous at this stage too. We prefer if somebody's taken voluntary departure at that point, because if they were granted voluntary departure and they left on time, then they don't really have anything. They don't have an immigration violation on their record at all. Actually, I will in another video talk to you more about the grounds of inadmissibility. If they had been in the United States for a year before they left and then they entered without inspection afterward, they'll also have a permanent bar, but we'll go into that more later. Number 15, have you ever violated 274C? No, nobody has, because that was enjoined right after it was passed. 16, have you ever, by fraud or willful misrepresentation of a material fact, gotten an immigration benefit? So, that is only an immigration benefit. That's not, have you used a false social security number or a false green card in order to get a job, or a social security number, or anything like that. That's only for an immigration benefit. The ones that we see is where somebody comes into the United States on a non-immigrant visa of some kind, knowing that they have immigrant intent, and lying about that intent. So when they're asked at the consulate, the U.S. consulate abroad, where they're applying for their visa, are you planning to stay in the United States? And they say no, but they really were. That is fraud or willful misrepresentation. Similarly, if they got a visa long ago and didn't at that time plan to live in the United States, but now they're using it again, and when they get questioned at the airport or at the border, are you planning on going back to Colombia for, to work? And the person says, yes, I'm still employed in Colombia. That is an outright lie, and that person will have to say yes to this and request a waiver of that willful misrepresentation. When you get people who enter with tourist visas, at first you feel like, yay, this is great, we don't have to do a waiver. But frequently, people, they just expect that they have to lie in order to be able to enter to live permanently in the United States on a visa that is specifically intended for somebody who does not tend to permanently live in the United States. There are circumstances under which somebody can enter on a non-immigrant visa without lying, maybe even 50% of the cases. But it's really important that we investigate this carefully when we see it. The same with alien smuggling. Somebody will initially say yes, but you'll want to say, Really? So when you got your tourist visa, the officer at the consulate didn't ask you any questions about your intent? Now, it could be that the consulate or the officer at the border said, what do you plan to do in the United States? And you say, I plan to go to Disneyland, and you did go to Disneyland, that's fine. It's only a question of whether you lied. Have you ever left the U.S. to avoid being drafted into the U.S. Armed Forces? Not many of our clients, and okay, none ever have. We've actually seen one J non-immigrant, that's a special internship kind of visa, where you have to go out of the country for 2 years in order to come, in order to adjust your status to some other kind of immigrant visa. I've seen one like this. Immigration has said that that can be waived, so we don't have to worry about it. And you just go ahead and say yes, and then you explain it. Detaining or withholding custody of a child, that is where there's a custody dispute and someone is taking a child out of the United States. It's something that the Immigration Service is extremely vigilant for, to make sure that nobody can get status who has kidnapped a child, whether it's their own child or someone else's. Polygamy, this is another one that always makes people chuckle. Polygamy is not inadvertent bigamy, like being married inadvertently to more than one person at a time. It is where somebody is intention. It is their belief system that they can be married to more than one person at a time. There are countries that do practice polygamy and recognize polygamous marriages, but it is never a woman that is allowed to be the polygamist. So that always makes our women clients laugh at the injustice of some countries. Have you entered the United States as a stowaway? That is only if somebody is hiding from the actual carrier. So somebody doesn't pay on an airplane or a ship or a bus or some other conveyance. That's what a stowaway is. Somebody who is hiding from the owner of that commercial conveyance, not from somebody who is sneaking across the border in somebody else's car. That is not what a stowaway is. It's an official term, a legal term. Okay. Do you have a communicable disease of public health significance? Most people don't, but some people may. Some people might have tuberculosis or HIV or measles, and they can say yes, and then that can be waived at this stage. The physical or mental disorder, 22B, that is likely to cause a threat to yourself or others. Some people have said in the past DUI or alcoholism was treated as that, and that could conceivably come up in some cases, and you should have a discussion with the person if they say yes, actually I have, I'm bipolar, and I have been, I've been institutionalized involuntarily because I was a threat to my family. Obviously, you'll say yes there, and we'll need to get letters from that person's treating physician to say whether that person poses a threat to public health or safety. In fact, although I've said everything can be waived, there's a much higher standard for somebody who may pose a threat to public safety. Interestingly, though, it's also if you have a disorder that poses a threat to yourself, that is included here as well. So if somebody is suicidal, that may come across in a letter from a therapist. It may come out in their declaration. It may come out in letters from witnesses that the abuse caused them to be suicidal. It's easiest if we just don't end up saying that, because it isn't necessarily relevant if you talk about all the other ways in which somebody has had that problem. The idea is if the person is currently suicidal, you'll want to say yes to this and request a waiver and have that person in treatment. If it was in the past, it seems like it opens a can of worms to say yes, if that yes isn't needed, because the person briefly said, I can't go on, to their therapist. So the therapist marked down suicidal ideation and included it in their letter. It doesn't, because it's not a current threat, we would prefer to say no here and have the therapist not include that in their letter. Because the person is not currently posing a threat. Have you ever been a drug abuser or a drug addict? I've had a couple of derivative new husbands who've said, yes, I did, and my wife straightened me out, and I'm very glad to hear that. So I always kind of wish they would just say no, but no, they say these yes, and they say these nice eloquent things, which I have included in the explanations in that explanation folder. Okay, information about spouse or children. This is whether it was the abuser, it's whether it was, it's just if it's a current marriage. So if you marked married up on page 1, you'll need to put all this information for that person. Sometimes people can't remember their abusive spouse or their ex-spouse, or somebody they've been separated from their date of birth, in which case you can say unknown or just put the month and the year. And you can say, so it's going to be spouse. And you can say current location unknown. So children, this includes stepchildren. So if you have a principal who marries her pareja, and which is totally fine, and he can be her derivative beneficiary once they're married, and they both have kids, be sure that you list his kids, which are now her stepkids, in the children section. Otherwise, it looks a little fishy that she's not considering his minor children to be her children. You say, what kind of marriage is that? So you want the child's all this relevant information. Now, you'll see that there's only room for 2 children here, and it says if more space is needed, attach an additional sheet of paper. And in our forms, in the attachments, in the stock answers to these questions, it just in fact, this very tippy top one is a form that's created in a program called InfoPath that makes it really easy to fill it out. So you can just fill out the same sort of thing that you would here in a PDF or in the Abacus form. It gives all of these as boxes. They're super easy to fill out and then print out. I should warn you, when you use an InfoPath form, you often have to click, yes, I really want it, yes, I really want it. You have to click past a couple of warning dialog boxes in order to be able to use it. So many people with children will have to use those extra forms. Even deceased children, stepchildren, like I say, children living abroad, adult children, all of them have to be listed, not just derivative beneficiaries. A lot of times I think people only want to put their derivatives here, but it's obviously their U.S. citizen children as well. So number 5, are you currently filing an I-918 application with your application? You can say yes, and then you will have those I-918s attached. Then the person will sign here. If we feel like we're going to be able to get this out within 6 months, they can go ahead and date this here. Otherwise, we'll wait and have them date it right before we send it. And then the preparer's name will be whoever the supervising attorney is. So either Susan Bowyer, and the email address is susan@icwiclaw.org, or it's Jessica Farb up here, and Jessica Farb at icwiclaw.org down here. And then our information here, and yes, they can contact us by email. So that's the 918.